62, the people of the state of New York versus Donovan Boyan. Counsel?
Good afternoon. Julian Joris for the People Appellant. I'd like to reserve 2 minutes rebuttal.
You may, sir.
Under this court's holding in Gravino, the defendant's SORA certification cannot be part of his sentence. The defendant in Gravino was not told anything about SORA at the time of her plea. Nonetheless, the plea was valid. Were SORA certification part of the sentence, at the very least, she would have had to be told, you will be certified as a sex offender. You will be a registered sex offender as a result of this plea. As a matter of fact, that's what the dissent in Gravino argued, arguing that, well, maybe we don't need to tell you all the details about the risk level, the exact registration obligations, because we can't know that at the time of the plea, but surely we should tell you that you will be certified.
Counsel, would your position be different? You know, here there were certainly offenses charged that would qualify, right? Attempted first-degree rape, I think, was charged here. And this is a result of a plea bargain where everyone agrees you'll take this burglary count and you'll be subject to SORA. Would it be different if there were no charges that were actually subject to SORA and the same plea is entered into?
No, that would not make the certification part of the sentence.
So
Now,
you could still say you're out of luck, you know, you pled to an offense that's not a SORA offense, but, you know, you're going to register for SORA.
I mean, that would sound like a relatively strong case for interest of justice review in the appellate division, but in terms of falling under the illegal sentence exception and presenting an issue of law, no, that would still not present an issue of law.
So did Gravino come up on an ineffective assistance claim?
I believe it may have, Your Honor, but off the top of my head, I don't recall. I'm sorry.
If that's right, well, let me put it this way. Was preservation raised in Gravino?
So what was decided in Gravino...
Yeah, I'm trying to get at
was-
what the parties were arguing. I think, and I'm not 100% sure about this, that it came up on an ineffective assistance claim which wouldn't have required preservation anyway, and there was no argument about preservation. Does that if that's right, would that change your interpretation of Gravino?
No, it wouldn't, Your Honor.
Okay.
Because still the holding of Gravino remains. It doesn't matter that you weren't told. That's still a valid plea. And if, right, so that has the same impact regardless of how procedurally it came up on the question of whether the SORA certification is part of the sentence or not. Because however it comes up procedurally, obviously you have to be told of the sentence in order to have a valid plea.
So is the mandatory DNA fee a part of the sentence?
No, mandatory fees and surcharges are not part of the sentence.
So then, this is sort of like Judge Garcia's question, if the court imposed a mandatory fee for something that didn't exist at all, it has to be preserved?
In order for this court to have jurisdiction, yes.
Yeah.
For the appellate division, obviously, has broader jurisdiction. But like the vast majority of claims, this would be subject to the preservation requirement. And I think this is a particularly strong case for seeing why that would be the case, because as was mentioned before, right, there were certainly in this case offenses that were indisputably SORA registrable. So if this had been brought up, the plea could have been worked out to something that was indisputably registrable. And again, for the other circumstances, the appellate division does have interest of justice jurisdiction. So allowing this to fall into the illegal sentence category, you know, I don't know, I can't say that it was gamesmanship in this case, but to hold that in addition to, you know, being contrary to Gravino, that would be to invite gamesmanship in future cases.
So am I correct to say that if we find that the SORA certification issue was unpreserved, in essence, we're saying that this was not an illegal sentence. You would go back, but the underlying issue, I think it's the burglary as a sexually registerable felony, is that correct?
Burglary as a sexually motivated felony.
Registerable felony for a SOAR hearing. That'll go back, and you can bring that issue, they could bring that issue up again at the hearing itself, couldn't you? At the SOAR certification hearing again? Not the sentence, but at the SOAR certification hearing.
So I don't know.
In other
that
words,
there-
the issue won't be lost, it'll just be brought up then. And it would be in a different posture, but nonetheless, the underlying issue itself would still be available for the defendant to bring up.
So I know that defendants do sometimes bring these claims at the SORA hearing stage. My view of it is that,
Well,
in
that
fact,
would certainly obviate any need to deal with the preservation issue and whether or not there was an illegal sentence, right? You see what I'm saying here? is
Yes.
I'm saying, maybe he's got an argument, maybe he doesn't. What I'm wondering is, does he have a way to bring that up? Outside of what I see as a relatively convoluted procedural approach to get at the underlying issue. See what I'm saying?
So I do believe the proper time to bring this up is on direct appeal. Now, if this court were to find that it's not part of the sentence, the remedy would be to remit for the appellate division to
Exercise
consider.
interest of justice jurisdiction should they choose to do so, right?
Absolutely, Your Honor.
And then even if you lose there, though, of course, he still could go ahead and at his SOAR certification hearing, bring the issue up then.
So I don't think there is a mechanism for that. I believe because it's part of the judgment, it should be raised on direct appeal.
But it certainly happens, doesn't it? At the SORA level assessment hearing, claims are made that these are not registrable offenses.
Yes, it certainly happens. I'm of the view that that's not a procedurally proper way. It's, the judges in the trial courts
No, I
seem to vary.
understand,
but
no,
yes.
I'm not deciding on the legitimacy of your procedural argument, it's a legitimate argument. But I'm just wondering, is the underlying issue itself preserved? And as to the nature of the offense being a sexually motivated felony, and it would seem to me that it would be, that you could make that argument there.
So I don't think it's preserved in the sense of preserved for appellate review, because this wasn't brought up at all at the sentencing. So that is why I believe that if this doesn't fall into the illegal sentence exception, that this is outside of this court's jurisdiction and there doesn't present a question of law, if that answers your question, Your Honor.
Thank you. Yes, it does, thank you.
So in the appellate division, the appellate division decision expressly says the people did not challenge the preservation, right?
No, the people did argue that it was unpreserved. We argued,
Well, I'm reading from it. We note the people do not contend the defendant's waiver of the right to appeal precludes from appealing the certification of the sex offender.
right, that was about the waiver of the right to appeal, not about whether it was preserved in the sense of was an objection made at the sentencing. And I see I have the red light, so,
Thank you.
thank you.
Counsel?
Good afternoon, Your Honors. Ava Page for Donovan Buyend. What the prosecution is asking the court to do in this case is to ignore decades of precedent regarding statutory interpretation to expand the correction law. This is a dangerous invitation that should be rejected because it would blur the line between the judiciary and the legislature.
Should we give your defendant his plea back?
No, Judge, that's not what we're asking for here. And unlike the defendants in Gravino, Mr. Buyend never challenged the voluntariness of his plea.
But it seems to me, in pleading out these sex offenses, part of the bargain was registration, then nothing said at sentencing, and then there's an appeal, and then it's not a registerable offense. So wouldn't the equitable remedy here be to put the parties back in the position they were in before this was imposed?
No, Your Honor, Mr. Buyend is not seeking to withdraw his plea. He's still serving his prison term and will serve his post-release supervision term. The remedy here is because he was illegally certified as a sex offender for an unenumerated offense, the remedy is what the appellate division applied, which is to vacate the portion of his sentence that is illegal. And this court has held over and over that the plain language of a statute must be given effect, and that courts cannot amend statute by inserting words that aren't there. So the
Counsel, I'm on the screen, hi. Could, in your view, could defendant raise this issue at the SORA hearing?
I think he could, yes, Your Honor, and the 6 cases from the Supreme Courts we presented to this court show that some defendants have raised this claim at the SORA hearing. However, 5 cases, the Supreme Court agreed with the appellate division's holding here, but in one case, the outlier case, Hernandez, the Supreme Court followed the prosecution's reasoning. And so I think that this confusion among the lower courts of how to correctly apply the statute calls out for this court's decision today.
So getting back to the statute, given that the provision of the penal law that's in dispute was part of a larger legislative package under SAMTA, where it seems to not fit in with the mental hygiene law amendment and the correction amendment, doesn't that seem like a situation that cries out for a reinterpretation of what it is exactly the legislature intended to do, notwithstanding the language of the statute?
No, Your Honor. The clearest indicator of the legislature's intent is the plain language of Correction Law 168A2. And the appellate division considered the people's argument that this would lead to absurd results. Maybe the memo indicated they intended to make all sexually motivated felonies subject to SORA.
And the fact that concurrently enacted legislation explicitly said sexually motivated offenses are to be included as part of the SORA process just doesn't factor into that analysis at all, because, you know, it occurs to me you don't even have to add words to the penal law section. You just have to drop a line and everything makes much more sense.
Well, Your Honor, the correction law defining what is subject to SORA and what is not was actually amended after SAMTA and the mental hygiene law, I believe. And also, if this court looks at the entirety of the correction law, it's clear that the legislature has been very specific in determining what crimes to include and what crimes to exclude. So there are many crimes involving sexual misconduct or motivation that the legislature has specifically excluded from SORA. And that includes sexual abuse in the 3rd degree, forcible touching, promoting prostitution in the 2nd and 3rd degree, patronizing a prostitute in the 3rd degree, unlawful surveillance in the 2nd degree. So consider, for instance, forcible touching. If a defendant is convicted of touching a 17-year-old woman's vagina on the street, he is subject to SORA. If he were to do the same thing, but the woman had just turned 18, he would not be subject to SORA under this statute. So some of us may think that that's absurd, and those are both clearly sex offenses that should be subject to SORA. But the legislature has the right to determine what crimes are exempt and which are to be included. And
But 168 actually says sexually motivated felonies. Those words appear in the correction law.
yes, Your Honor, and they're limited by the language in front of it, which says the aforegoing section. So all the enumerated crimes, which are sexually motivated felonies, are subject to SORA, the same way it limits which hate crimes and crimes of terrorism are subject to SORA. And the problem with the standard that the prosecution is asking the court to adopt is that it would allow every judge in the state of New York to substitute their subjective determination of what should be a sex offense or what the legislature might have intended to be a sex offense for the black letter of the law. And this would lead to a chaotic, unworkable standard where a judge, take for instance unlawful surveillance in the 2nd degree. It's also a felony where the legislature chose to make certain subsections not SORA subject. So consider a defendant that's convicted of putting a hidden camera in a gym changing room, recording people naked and posting that footage on the internet for the purpose of making money. So that's currently not enumerated. A judge in New York County could look at that crime and say, well, this is not enumerated, therefore I cannot make this defendant subject to SORA. but a judge in a different county or even that same courtroom could, applying the people's logic here, argue that's absurd. This is clearly a sex offense. This is a gross invasion of privacy. The legislature's intent in passing SOMTA was to protect the public from sex offenders and to provide monitoring, and I think this is the exact type of crime that calls out
But
for
isn't this
SORA.
different, Counselor? Because when we read it in accordance with SOMTA, which says that it is amending the list of registrable crimes so that a defendant convicted of a sexually motivated felony will be required to register. So there's really no guesswork there. Aren't we allowed to interpret, and isn't construction part of our domain?
When the law is unclear or ambiguous or would lead to absurd results. In this case, I would argue that the law is clear, and this court has clearly stated that when the language of the statute is clear, it must be applied, and the court is not permitted to divine legislative intent.
But if we adhere to your interpretation, you effectively read the passage that Judge Singas just quoted from out of existence, because sexually motivated felonies will not be registerable.
That's not true, Your Honor. The statute, subsection 3 as it stands, specifically enumerates which sexually motivated felonies are subject to SORA. Actually, the prosecution's argument would have this court write
Well, no, they
into...
just list a number of felonies that are subject to SORA, but the sexual motivation is a separate part of the penal law, isn't it?
Well, under the way the statute's currently written, there are 6 sexually motivated felonies that are enumerated and 20 that are not. So the people's argument would have this court not only add in at least 20 unenumerated offenses to the statute that the legislature did not see fit to include, but also
So
add
the
in...
net effect of your argument is that essentially there are 6 registerable sexually motivated felonies. And the second part of the list, if the sexual motivation count or part is appended to it, would not qualify.
My argument is that the way the statute is written, the legislature specifically lists which crimes are subject to SORA and which are not, and that we cannot assume that those that are excluded are meant to be registrable. And in fact, there's an inference that that which is excluded in such a detailed statute as this is meant to be excluded. And
Can I ask you the same question that I asked your opposing counsel? Let's say we disagree with you. On preservation, we say that this is not an illegal sentence and it had to be preserved. Can you go back at a SORA certification hearing and raise the underlying issue again?
I think it could be raised, Your Honor, but I think this is really an issue that cries out for the court's resolution today, and I would just briefly note that this court has continually held that certification is part of the sentence and has never allowed an illegal sentence to stand.
Yeah, I understand
Well,
your
to
argument.
there, I just want to tease that. I wanted to go back to this, but looking at paragraph 1A of section 168D, the last sentence says, failure to include the certification in the judgment of conviction shall not relieve a sex offender of the obligation imposed by this article. Doesn't that defeat your argument that certification is part of the sentence?
Not at all, Your Honor. To me, that is clearly distinguishing between certification and later registration requirements, which are collateral. So certification, which is imposed at sentencing, which must be imposed at sentencing, is part of the sentence, just like someone's predicate status. But the SORA registration requirements, which this court considered in Gravino, are clearly collateral. They only commence when a defendant is released from prison after he's served his sentence.
Thank you, counsel.
How do you reconcile Wyndham, though? I'm sorry, Judge.
I'm sorry, Your Honor?
How do you reconcile our holding in Wyndham, where we held that the risk level determination is not part of the defendant's sentence?
I think that squares perfectly with the result we're asking the court to come to today. The SORA risk level is a civil proceeding that occurs when the defendant is about to be released from prison and determines what his registration and notification requirements are. Certification happens at sentencing, becomes part of the uniform and commit sheet, and in fact, the court is mandated to enter it at sentencing if the defendant is convicted of a sex offense as defined by Correction Law 168A2.
And how do you contain Gravino? I think you said it, but I sort of missed it. Could you just explain, because I know it says that it happens during sentencing, but it seems fairly explicit that it's not actually part of the sentence.
Well, Your Honor, in Gravino, both defendants pled guilty to enumerated sex offenses. So they never challenged the propriety of their certification. Their certification was clearly legal. The defendants in Gravino tried to take their plea back when they found out about the registration requirements in terms of having their picture on the internet, all of the notification that would come after they got out of prison. And this court held in Gravino that registration is a civil collateral consequence that is not part of the sentence and does not make a plea involuntary. But I think it's important to note that the same court that decided Gravino, thereafter, the same justices decided Smith, where the court reiterated that certification as a sex offender is part of the sentence because it happens temporally at sentencing. The judge is mandated to apply it at sentencing, and it's unlike a registration hearing, which is not part of the criminal case, but is a civil proceeding that happens when the defendant is about to be released from prison. Does that answer Your Honor's question?
I do. I'm just going back to Smith for that unequivocal statement that you're referring to. But you can move along.
It's in footnote 2, Your Honor. And my point in bringing up Smith is that Gravino was decided by the same justices that decided Smith, which clearly show an informed court differentiating between certification, which is part of the sentence, and registration, which is a collateral consequence.
Thank you, counsel.
I'm sorry, Judge.
Yes, go ahead, Judge.
But it seems as if the footnote in Smith quotes as authority Hernandez, and I don't think Hernandez actually says what this footnote claims it says.
Well, Your Honor, in Hernandez, the court did hold that certification as a sex offender is part of the judgment of conviction.
Judgment,
And yes,
different than sentence.
but in Smith, the court also, who had just decided Gravino, considered this again and reiterated it is not only part of the judgment, it is part of the sentence. So just like predicate status, if someone is illegally sentenced as a mandatory persistent, the courts automatically remove that part of the sentence and sentence the defendant legally. So our argument is that certification is just like predicate status, and an illegal certification for a crime that's not a sex offense is part of the sentence and cannot stand.
Thank you, counsel.
Thank you.
Counsel, your rebuttal?
Thank you, Your Honor. I just want to make clear what our argument is about why the defendant's reading of the statute is unreasonable. It's not that, well, sexually motivated felonies exist, and therefore anyone would want to make those registrable, therefore they must be registrable. It is the legislature put this language in referencing sexually motivated felonies into 168-A, and if it doesn't make sexually motivated felonies registrable, it doesn't do anything. It neither expands nor contracts the category of registrable sex offenses. All the sexually motivated felonies that are referenced in that provision separately, they were already in there. They were already registrable, and they're already enumerated. So what is unreasonable is not that, well, there's the word sexually motivated in there, therefore they must be registrable. What is unreasonable is imputing to the legislature.
So counsel, what's the point of the specificity in the statute? Why have a partial list? What's the point of that?
So SORA originally listed specific enumerated offenses. About six of those offenses, once the category of sexually motivated felony was created, could become also sexually motivated felonies. Now, sorry, are you asking essentially why the literal reading of the statute says or committed as, that it does?
I'm just trying to understand your argument. As I understand it, you're saying that the legislature developed one broad category, and so we should ignore the explicit category, which seems to me contrary to the rules of construction. But I'm just trying to understand what you think the legislative goal or intent is, given the language that you're referring to. Why have enumerated, right? Why keep that? Why not repeal that? Why not make clear that now you mean all of them?
That would have certainly been a clearer way of drafting the statute. And there's no argument that if you read the statute in a blindly literal way, the only sexually motivated felony...
Well, isn't that what we're supposed to do? To read the statute when it's clear and unambiguous on its face?
That is certainly the starting point, Your Honor. But my argument is that...
Okay, where have we ever said that's the starting point and there's many more steps to be taken?
I believe I cite 2 or 3 cases in my brief, Your Honor, for the proposition that when the literal reading leads to an unreasonable result, then the court can step in and do something other than the literal reading. And
it's unreasonable, I just want to clarify, it's unreasonable because certainly the legislature would have wanted to cover all of these sex offenses, or because we look to some other statute and we can intuit that that's what it meant?
First, it is unreasonable because if this clause referencing sexually motivated felonies doesn't make them all registrable, it does nothing. Then it just says things are registrable that already, independently enumerated, were registrable. So that it's not reasonable to impute to the legislature a desire to put in language that does nothing. So that is really the core of it. In addition to this, we do have the language, I believe, which was alluded to during my adversary's argument from the introducer's memo, the governor's memo, the Division of Budget memo, all saying 168-A has been amended to make all sexually motivated felonies registrable under Megan's Law, SORA. But really the unreasonableness of the reading comes from the fact that the literal reading, again, it would just say things are registrable that already were registrable, and it would therefore be redundant.
Thank you, counsel.
Thank you, Your Honor.